you're anything like me, you would have brought a cricket bat or booked Coldplay tickets on bookmyshow.com and ticked, I agree to all terms and conditions without reading any. These are contracts. If you've taken an Uber, that's a contract. You and I enter into contracts every day without realizing that we're entering into one. What constitutes a contract? There are three primary elements of a contract. The first is an offer and acceptance. The second is consideration. And the third is an intention to create legal relations. Offer and acceptance. If you take your old cricket bat to a used sports goods store and say, I'd like to sell this to you for 300 rupees, and if the shopkeeper accepts, that is an offer that you have made and an acceptance on behalf of the shopkeeper. If the shopkeeper looks at it and says, no, I think I'll only pay 250 for it. I don't think it's worth 300 rupees. That is a counter offer made by the shopkeeper and not an acceptance. If you then accept that, that forms a contract. The second element is consideration. In simple words, it's something that flows both ways. So you have given the cricket bat and you have received 300 rupees in return. Something is flowing both ways. If, however, you simply offered the bat to the shopkeeper and took nothing in return, that would become a gift, not a contract. And the third element is an intention to create legal relations. So, for example, if instead of going to this shop, you went to a party, and at the party you told a friend, hey, you know what, I'll sell this bat to you for 300 rupees. And if he agreed, or she agreed, that is not something that formed a contract. It's informal. There were no intentions to create legal relations. So the three elements of a contract are offer and acceptance, consideration, and an intention to create legal relations. Now, we've spoken about the smaller contracts, like buying a Coldplay ticket. There are much larger cross-border contracts between large companies seated in two different countries. That is the kind of work I do. The reason I'm able to do that kind of work is because I studied law in India and practiced here for a little bit before I moved to London. I had to re-qualify as a barrister in London and then registered at the DIFC in Dubai to be able to practice at the DIFC court in Dubai. This is unique because lawyers usually are admitted to practice in just one jurisdiction. It is because of the various elements of studying in different jurisdictions that one can become a cross-border lawyer and advise their clients on international legal issues. So I'll give you an example of some of my day-to-day. One of my cases involves a loan agreement and a default of that loan agreement. But it involves three parties in three different countries: India, Mauritius, and England. Three parties. My client was a bottler of Coca-Cola based in India. They decided to venture into a cruise ship business abroad, and in order to buy the cruise ships, they needed to raise funds. So they went to Punjab National Bank, London branch, and the London branch agreed to loan a sum to their wholly owned subsidiary in Mauritius. So three parties here: the lender based in London, the borrower based in Mauritius, which was the wholly owned subsidiary, and the corporate guarantor, which was my client, based in India. Sadly, the business did not do as well as expected, and the loan had a default. Now, my client was a good man, and he said, don't worry, I have a thriving business in my Indian companies. So here, he goes to Punjab National Bank in India and says, oh, here's all of the money. Please transfer it to PNB in London and repay the loan. But cross-border contracts are not quite as simple as that. So the Reserve Bank of India stepped in and said, hang on, guys. This is 20 million euros. This business has nothing to do with India. Why should I allow an Indian company to send money abroad? So the RBI said, no, sorry, you can't do this. This suddenly became a good defense for me to take before the court of England and Wales. So I could stand up in court and say, dear judge, my client, the corporate guarantor, is willing to repay the money, but it is illegal for them to repay the money because it is illegal under Indian law since the Reserve Bank of India has said they can't do it. Can you see how complex cross-border contracts can become? Another example that went to court in England, and which is also the flavor of the season this year, this past year, at the English courts, is sanctions cases. Now, what is a sanction? A sanction is something usually imposed by a country against individuals and corporates in another country. I'm specifically referring to the Russia sanctions. The Russia sanctions have been imposed by the US against hundreds of individuals and companies based in Russia. This has also been adopted by a number of other countries, such as the UK, Europe, and so on. So in this particular case, my client was a publicly listed company on the London Stock Exchange. They were a stockbroker in London. So they had many clients. They had clients from India. They had clients from Russia. This particular client was a Belarusian bank. So the Belarusian bank had offered to their customers in Belarus to be able to invest on the London Stock Exchange through this broker. So they had about $40 million worth of investments in this brokerage in the UK. Now the sanctions were imposed on the ultimate shareholders of the Belarusian bank. So suddenly, because the sanctions were imposed, no assets could move. No asset can move once a sanction is imposed. It has to be in the same condition, lying in the same place. So even though my client in that instance was willing to, once again, return the 40 million to the Belarusian bank on demand, which is what most brokerages would do, it was unable to do this because sanctions had been imposed and it had to abide by the English law in this regard. So this is another example of how complicated it can get. But the reason I'm sharing this with you is because that day, I was really proud to be practicing English law. So the judge said when he received these papers, despite the very strong rhetoric against Russia in England, the judge said, I agree that all of this money belongs to the Belarusian bank, and I will freeze everything so that the British entity cannot dissipate the assets or cannot do anything, cannot use or dip into that pool until such time that the sanctions may be over in 10, 15, 20 years' time. So the English courts were therefore perceived, and this is an example of why they're perceived to be fair and neutral. The two examples I've given you thus far are both litigation. Litigation is something that goes to court. The dispute could also have a slightly different manner in which it could have been resolved, and that is called arbitration. International arbitrations are what I specialize in. So can you imagine if we closed all the doors to this room, we did not allow anybody to come in, we put a long table down the center, one party with their lawyers on one side and another party with their lawyers on this side. And then we can have 3 judges here. They're called arbitrators because they're not sitting in a courtroom. They're sitting in a closed door environment. This room then becomes an arbitration hearing room. Nobody outside these walls will be privy to what is happening inside. And that means that everything that happens here is confidential. Confidentiality is one of the most, it's an advantage of arbitration and a reason that a number of parties opt for arbitration. A simple example of an arbitration would be if you graduated from BIS and had a startup and had a Singaporean investor into your company. In the contract that you would have between yourself and the Singaporean investor, you could say that, well, hopefully nothing will go wrong, but if 5 years down the line something were to go wrong between us, let's agree to have our disputes resolved by arbitration. But you would have to choose where you would have to have these disputes resolved. So of course, you're not going to agree to Singapore because the opposite parties from Singapore, you would think, that's not a neutral venue. The Singaporeans will not perhaps agree to India because they would not perceive India as a neutral venue. So the two of you can decide, well, let's go to a neutral venue, let's say Dubai or London, and let's have our arbitration seated there. Now, there are 2 choices that you have to make. One is your choice of forum. So you would choose, for example, an arbitration seated in London, or you would choose a courtroom seated in a particular country. But the second element that you need to put into your contract is what law you would like to have it governed by. So if you have two Indians, it must be governed by Indian law. But if you have a foreign element to the contract, you can choose to have that contract governed by any law. It can be Singaporean law, English law, and so on. It is said about 25% of the world's contracts are governed by English law. And that brings me back to my day-to-day. The practice of English law and the practice of resolving disputes between parties in two different jurisdictions that may have nothing to do with the British economy, but they just had faith that that court or that arbitration center will resolve their disputes in a fair and neutral manner. Thanks.
Thank you, Karishma. We'd now like to open up the floor for questions.
I actually had a question on the arbitration bit, which is that if you were to choose a like a third jurisdiction, the examples you gave at the beginning were kind of like the Indian government blocking like a currency outflow from the country. Wouldn't that still be applicable even if you chose a random or like a third country's law, or does that kind of circumvent those kind of rules?
That's a really good question, and that is the complexity of cross-border law. So if the arbitration is seated in London, then one would need to choose or see whether under English law it could respect foreign law. So it could be that London decides that if the contract is illegal to perform rather than invalid in India, then it would respect the Indian law on that subject. But if it was just invalid, that the court would still just would go ahead with the dispute or disallow the submission of Indian law on the point. It's a bit technical, but it goes down, it really goes to the heart of the cross-border practice, which is what elements of which law can be argued and upheld in a foreign forum.
Thanks. Really cool speech, by the way.
Yeah, we will take one more question.
Yeah, hi. Given that you've practiced in India as well as overseas, could you just tell us about how Indian courts and the English courts are perhaps a little different?
Sure. The application of the law is very similar. The Indian law, of course, a fair bit of Indian law, although now it has changed considerably, is also based on English law. So Commonwealth jurisdictions are similar, but procedurally it's quite different. And that means there are set deadlines in England that we meet. There are no adjournments. So it's quite unlike what one sees in an Indian courtroom. The way I conduct myself in court, for example, in India would be entirely different from the way I would make submissions in England as well. And the written drafting is dramatically different. It's more succinct in England, and again, it is all disclosed to the other side in advance. So no surprises. In India, you can walk into court with a bunch of new judgments and literally stand up and hand over the judgments to the other side there and then. There are no surprises in England. You have to share everything in advance.
Thank you so much for your invaluable insights, Ms. Karishma.